Welcome, everyone. Thanks for being with us for another one of our quarterly webinars. We are doing 2 quarterly webinars each quarter. One is geared toward our financial planning topics, and in this case, we are taking some time in that series to talk about estate planning. Each quarter, we also do a outlook on the economy and the markets to keep you in tune with what our expectations are and how that's affecting our portfolio strategies. But of course, the financial planning context is the important element to inform how we think about our portfolios, and we wanted to take time to address that as well. I'll be offering some introductory comments and discussion points that I want to bring to your attention. And then I'll be turning things over to my brother, Keats Boyd. Keats is the president of Boyd Boyd P.C. And for those who have been to our Cape Cod office, we're located in the same office suites, Asset Management Resources and Boyd Boyd in our Cape Cod location. And so we have the opportunity to have some nice synergies when it is that clients happen to work with both our firms. You'll find out, if you've not heard Keats before, he's just a wealth of great information, and I'm sure you'll find today's presentation very useful. Today, we're going to be just giving a little overview here. I'm going to introduce you to a couple of new members of our team. We've got, I want to address our locations briefly, and that we have some additional webinars coming up to keep you aware of. And then I'll turn things over to Keats, and he will jump right into our program. We are saving time for questions at the end. If you do have questions, you're welcome to raise your hand for the Q&A. There's a Q&A box. You can type in questions. You can use a chat room as well. And if you raise your hand, we probably will wait till the end to actually turn on your mic to ask questions if you wanted to do it verbally. So all of those are possibilities, and we welcome any of those. And Kathy will be monitoring the Q&A. If there's something that you think is particularly relevant at the moment, feel free to chime in with your question, and we'll determine whether to use it then or later. So let me introduce you to a couple of quick, we have some new additions to our team at Asset Management Resources. First among them, about 3 months ago, we hired Jeff Tamanning. Jeff is an experienced financial advisor. He's been working in the field for some 25 years, and he has amassed more professional designations than I think anyone else I know. He is well experienced and well credentialed. In addition to being a CFP and a CIMA, he has all these other designations. And I think the reason I mention this is just to give you confidence that if you speak with Jeff, you'll know that he has the background and experience that can be a resource to you. Jeff is also, we met because we both shared leadership role in the Financial Planning Association of Massachusetts. Jeff immediately followed me as the president of the board of directors for the Massachusetts chapter. In addition, he has been an instructor for people going through the CFP program, quoted in numerous professional and local or business minded articles, and is among America's top financial planner in the 5-star wealth management Investopedia 100 member. So lots of great credentials. It's our expectation that clients will continue to work with me and other members of the team in a team effort. No one's changing their advisor. You will still have contact with me and others, or Mike in the case of Mike's clients, Mike Perna's clients. So nothing is really intended to change in that respect, just simply the opportunity for greater depth of resources. We do work as a team, and there are times when people want to speak to someone more promptly And so it's our hope that Jeff and his clientele will, be able to, join our firm, but Jeff will be available to be a resource to our clients as well. We also hired Jeff Perry, who is known to people on the Cape, presumably, as someone who's been a personality of great recognition. He's had 20 years of professional experience as serving the community and providing education to the public. He's a JD, a lawyer himself from the New England School of Law. He most recently retired from the Barnstable County Sheriff's Office as the special sheriff, which is the #2 position there, and in no small part to his own passion for personal finance and his ability to prepare for his retirement at a young age. He also has served as an adjunct professor at the Cape Cod Community College for 13 years. And so, his role is going to be with us, someone who is focused on education and helping clients further their financial security. So because of his time both at the sheriff's office and having served as a state representative for the 5th Barnstable District, Jeff has just a wealth of contacts, and he's eager to try to help as many clients or people as he can, friends and contacts, by providing services through our firm to help people with their financial life on their financial journey. In the fall or the turn of the year, we're hoping to also introduce a new program that Jeff is going to be instrumental in developing with us. That's going to be a mentorship program for people just starting out in their financial journey. So with that, I also wanted to just touch on our locations, because we've had some questions. We mentioned that over the last few months that we've opened a Boston office in addition to our Hyannis office. And that raised questions from people, like, will you still have a Cape Cod location? Absolutely, we will. And we continue to have that. And that's, our primary location for myself, for Kristen, other members of the team. We have also, and Brian Regan primarily will be present in our Boston office, but we will use that for client meetings as appropriate. We also have clients who have been associated with Mike Perna's office, and during the pandemic, we stopped having a Dedham office temporarily, but we want you to know that we've made arrangements for location in Dedham where we can meet with clients. It is going to be by appointment only, but whether with Mike or other members of the team, we will be available to you for scheduling those appointments. Particularly, I wanted our clients who've been working with Mike Perna over the years to be aware of that. Mike is still active and will be part of your team, but we also can be a supporting role as well. If there's any way any of the rest of the team can be a part of that process, we're here to serve you as well. And of course, we did have Scott Birmingham move to Nashville during the pandemic, and he has been working out of that area. So we have extended our radio show to not only be on the Cape, but also in the Nashville market. And we will look to develop some presence in Nashville as well. So if you have any friends or family in that area, feel free to share that we can be of help to them there. Lastly, before I turn things over to Keats, we wanted to let you know that we do have additional webinars planned. Certainly in July, we'll start the next quarterly economic market update. But in the meantime, we're paying very close attention to some of the proposed tax policy changes. And it's, I think, something that's of great interest to our clientele. So we thought we would plan to put together a webinar with that in mind, and an opportunity for some discussion as well. So we have not ironed out the details of this at this point, other than to select the date that we will look to have this available for you if you should be interested. So look for more information as we iron out those details. Wednesday, June 23rd at 4 p.m. is when we plan for that. So with that, let me turn things back to Keats and allow him to take over the screen if he would like to. And I will pass the baton, if you will.
All right, Chris, I might ask you to actually continue with your screen because I'm having difficulty getting the PowerPoint.
Absolutely, not a problem at all. Let me put
most
that back
efficient
on for our viewers. So. Take it away, Keats. Can you see my screen?
Thanks, Chris.
Yeah.
All right, so we're going to be talking today about estate planning, particularly in this year when we're dealing with a very changing environment. I just have to give a general disclaimer that the information we're going to give today is intended to be informational in nature and educational. It might be considered advertising under some state bar rules, so keep that in mind. Please do not think anything I'm saying today is meant as specific legal advice to your situation. All right, Chris. Here's just an overview of what we're going to go through today. I want to just touch on the basic building blocks of an estate plan and some of the basic tools that should be in most estate plans today. I want to talk about some of the problems about Medicaid planning, especially for those without a diagnosis. There's an awful lot of information about Medicaid planning. Everybody seems to be talking about it at a cocktail party. And really, for many people, it's the wrong approach. And so I just want to make sure we talk about what are the pros and the cons. There are times where Medicaid planning is a really important idea. There are times where it's not a great process for certain clients. I want to go into some of the tax law proposals that are out there right now. There's really three of them, one from President Biden, one from Bernie Sanders, and one from Chris Van Hollen. All of these proposals look to really change the tax landscape dramatically, both for income and estate tax planning and the interplaying of those two areas. It does kind of make a chilling effect. One of them is retroactive to January 1st if it's passed. And that would mean that if we try to plan in advance of the law being passed, we could be caught in a trap. We've got some workarounds for this, so I don't think this will be a great problem, but I want to point out it's an issue. And then, why you should plan now to avoid some of these retroactive taxes. I want to touch on the importance of limited liability companies and why they're a great tool in estate planning and why people should be thinking about incorporating them more than they have been thus far. And then finally, I want to just touch a little bit on blockchain technology. Until this last week, Bitcoin and Ethereum, these things have been on a tear. It's really been kind of a bull market there, and it's gotten a lot of people interested in this area. I think for many people, the idea of blockchain is not so much the get rich quick or the currency trading kind of a concept, but it's really the technology that lies behind it and how this is going to impact estate planning in the long run. So we're going to talk a little bit about that, and then we'll get into Q&A. All right, Chris, if you could advance the slides again.
There's a little bit of a delay from the time I do it, sorry.
Okay, no problem. All right, so estate planning goals. There's 5 of these bullets that will come down. The first one is passing wealth to your heirs at death. That's what we think about with estate planning. We typically think of a will. The second goal is incapacity care planning. What happens if you're unable to take care of things for yourself, you're alive but incapacitated, who's going to be in charge? The third objective for most estate plans is to avoid probate. Probate is that process of changing ownership from the name of the decedent to the names of the heirs, and it can be a time-consuming and expensive process. And it's not private, it's public. So we want to avoid it for all 3 of these reasons. The rule of thumb is it's going to cost about 5% of the value of the assets going through probate. And it's going to take typically, at least in Massachusetts, about a year to a year and a half, but definitely a minimum of 1 year to get through probate. And then it's all public record. So your personal financial information will end up in the court that's accessible by anybody who wants to ask for the file. So I think for these reasons, people want to avoid probate. And there's a number of techniques that you can use to make sure that that's going to happen. The fourth objective for most families now is asset protection, making sure that nobody can reach into your pocket and take assets away from you so you can't enjoy them during your retirement years. And so we want to make sure that that's addressed. We also want to make sure it's addressed so that when you leave a gift to your loved ones, it's going to stay with them, that it's not going to be lost in a divorce, a bankruptcy, a lawsuit, or even for estate taxes when the kids die. And so asset protection becomes an important issue there. Finally, we have tax avoidance, both on the income tax level and the estate tax level. And for the last several years, I've really been emphasizing income tax avoidance being the most important aspect in the estate plan. And most estate plans really weren't addressing that. And I think that's really important because right now, the estate tax exemption is $11.7 million. So federally, most families aren't impacted by the estate tax. It's capital gains taxes and the Affordable Care Act surtax that really becomes a larger bite of the estate. And we want to try to preserve assets so it ends up with the family rather than with a government entity. And finally, there is a state tax, and we're familiar with that. We just want to make sure that we're minimizing the impact of that, because in Massachusetts, we still have a state level estate tax. And even if we have clients who are Florida residents, if they still have a tie to Massachusetts, like real estate located here, they are still subject to the Massachusetts estate tax. So we want to make sure we're addressing that in our planning process. All right. So our typical building blocks include the things that you see on the screen. Many of them will be familiar to you: the healthcare proxy or living will, power of attorney, a will. These are common tools that most people are aware of, but there are a few things here that you might not know about. A contract to plan, which is an agreement between spouses to say, basically, I promise to give everything to you, you promise to give everything to me, and we both promise that when the second of us dies, we give it all to our kids or to whomever the beneficiaries are supposed to be. This is to protect against things like a surviving spouse remarrying and leaving everything to the new spouse. And the kids from the first marriage end up getting nothing. If the surviving spouse dies before the new spouse, everything will end up going to the new spouse. And then the new spouse, when they die, would leave it to their own heirs. So a contract to plan helps to protect against that. And it's an important addition to the estate plan. It's something that we've started working with a couple of years ago. And if you don't have one, I really urge you to consider adding it to protect against undue influence of a healthcare worker for your surviving spouse in their senior years, the accidental disinheriting through use of joint property in an inappropriate fashion, or leaving something to a new spouse after the death of the first spouse. So all of these things can be protected by that contract to plan. Of course, the centerpiece of the modern estate plan is the revocable trust, a trust that you can cancel or amend at any time. And we like to add PAT provisions. PAT is an acronym that stands for the Personal Asset Trust. It is a tool through which we can leave assets to our loved ones, but keep the inheritance in a trust and have it accessible by the beneficiary, because very often we'll set up the beneficiary to be the trustee of the inheritance they are receiving. But keeping it in a trust for that beneficiary and their descendants, or the descendants of the person who creates the trust, so that this is an ongoing trust and it lasts for multiple generations. And this way, the inheriting party doesn't actually own the assets. And because they don't own the assets, the inheritance can't be taken away from them through a divorce or a lawsuit or a bankruptcy, or it won't be subject to estate taxes when the heir passes away. So for all of these reasons, a personal asset trust can provide a lot of protection for both wealth preservation and making sure that the heir can do really whatever they want with the inheritance, that they're not going to have limitations on them. It's they want to spend the money, then they can take it out and spend it. But if they're going to invest the inheritance, they keep it in your trust, and that provides protection. I had an associate a few years ago who used to compare this approach to, outright distribution. You can bring a wheelbarrow full of cash up to your heirs, and on a windy day, they're not going to get it all. It's going to blow away. Or you can bring it up into an armored truck, which is like the personal asset trust, and it's going to be protected, and the wind's not going to matter. They're going to have their inheritance intact and protected. And that's really what we're trying to achieve with the personal asset trust. Then we have trust to receive retirement accounts, IRAs, 401ks, 403bs, any kind of qualified retirement plan. I argue that you should probably leave those to a spouse if you're married, But instead of leaving it to the kids, leave it to a trust for the kids or whomever your ultimate heirs are intended to be, if nephews, nieces, whatever, individuals, whomever you want, but put a trust between the retirement account and the beneficiaries. So the IRA is here, the trust is here, and the beneficiaries are below the trust. So the IRA money will come out to the trust and it'll sit there like a bucket. Again, the kids can be in charge of it. So they can say, well, I want to take some out to spend. I want to buy a new car. I want to take a trip. I want to pay my bills. No problem. But if they want to invest it, they leave the retirement account in a bucket and it will stay there for them to invest, and it will have that same protection as the personal asset trust. So if there's a divorce, the divorcing spouse can't say, well, I'm going to take half of it with me, because they're not the beneficiary. It's not a marital asset. It's still owned by a trust and it gets asset protection. Same is true for a bankruptcy or a lawsuit or estate taxes when the beneficiary dies. There was a recent change a couple of years ago called the Secure Act, and it went into effect at the beginning of 2020. And if you have an IRA inheritance trust and it's not been updated because of the Secure Act, you really need to do it. The old way was that the money would come to the IRA and pass through it. The Secure Act method, we keep it as a bucket. So the money comes into the IRA trust and it stays there until the child decides to take it out, rather than having to take it out automatically as soon as it comes in. So the Secure Act amendment is an important addition. And the reason it's important is now retirement accounts have to be taken out no more than 10 years after the death of the original IRA owner. So if you've got a qualified retirement plan, you pass away, you're leaving it to a non-spouse, the general rule is it must come out of that retirement account within 10 years. Furthermore, the IRS has issued guidance this year that said during years 1 through 9, the beneficiary must take at least a minimum distribution based on their life expectancy. This is relatively new, and it's something that is required during years 1 through 9. Then in year 10, they have to take out whatever's left. Now, in years 1 through 9, they're free to take out more than a minimum distribution, but they're not going to be allowed to take nothing out in years 1 through 9. When the legislation was first passed, we thought that was part of the deal, that you could leave everything in years 1 through 9 if you wanted to, or defer taking anything out. That's not the case from the IRS guidance. They're saying there's still a minimum distribution. I'm often asked if you can just use a revocable trust to be the beneficiary and get asset protection that way. And the reason you shouldn't do that is most revocable trusts will be stuck with a shorter time frame, a 5-year payout rather than the longer 10-year payout. And so for that reason, we don't recommend naming a standard revocable trust as the beneficiary of a retirement plan, but instead use these specialized IRA inheritance trusts to make sure you're going to get the most delay and opportunity to defer and get tax deferral in that retirement account, so the money can stay up in the IRA as long as possible, subject to the minimum distributions, and then be pulled out in year 10 if need be. That can oftentimes get the best tax results. There's a lot of tax planning now that comes with these as well. So there's a lot of issues with retirement accounts as far as what's the right course of action. If you have an estate plan that involves a trust, you have to have what we call funding documents, documentation to show that your trust owns things. It's really important that you have this in place. For example, there has to be an investment account that shows the trust is the owner and that the trustees are the people who have custody and the right to call the financial advisor and say buy and sell, or set up the strategy, or do whatever is appropriate. So you have to have the right documentation in place to do that. Next, we have limited liability companies. We're going to talk about those in a second. And then finally, irrevocable trusts now are going to become a basic building block, especially if some of the proposed legislation comes to pass. Irrevocable trusts have a great opportunity for many clients when we're looking at the what's in it for me kind of a question. Most estate planning that we've talked about so far is really for the benefit of your heirs. How do we make it so that it's for your benefit? Irrevocable trusts and limited liability companies are two of the tools that we use in our toolbox, if you will, to make sure that a client gets benefit when they're doing their estate planning. And these can be income tax reduction, income tax shifting, estate tax reduction, and asset protection. All of these can be had through the use of either limited liability companies or certain types of irrevocable trusts. Okay. All right, Chris, that would be a good
Keats,
time.
just in passing, you mentioned the Secure Act and the importance of how that has created some changes. And I know last year we recorded a discussion about that. Is that
Right.
still available on your website?
It is. It's on our website. We have a seminars page at boydandboydpc.com. And if you go to that website, it's available on demand. It will talk about the Secure Act. At the time we recorded that, we were under the impression that the 10-year payout in years 1 through 9, it was optional to take anything out. After we recorded it, the IRS issued guidance saying you must take a minimum distribution. So, you know, that's available on the website. And there's a few other webinars that are available on demand on the seminars page of the boydandboydpc.com website.
Thanks.
All right. Medicaid planning. You've probably all heard about, you know, is your trust revocable or is your trust irrevocable? Oh, my lawyer gave me an irrevocable trust and all my assets are going to be protected from the cost of nursing home care after I set this up for 5 years. Well, many people don't realize what they're getting into with these kinds of trusts. They're called Medicaid Planning Trust, MPTs. They're also called Irrevocable Income Only Trusts, IIOTs. And, you know, the issue is, can you guarantee me that you're going to need nursing home care? Most of us don't know that. You know, if you've got a diagnosis of MS, Parkinson's, dementia, Alzheimer's, or some other debilitating disease where we know a nursing home is in our future, then you should be considering one of these kinds of trusts. But if you don't know that, be really careful, because most people don't really understand that what they put into these trusts is no longer theirs. The only thing that they are keeping when they put an asset into these kinds of trusts is the income the asset can generate. You know, so for example, people will put their home into one of these trusts. They have the right to live in their home for the rest of their lives. But if they wanted to move to an assisted living community that has a rental model, if they sold their home, they think they're going to be able to use the equity of the home to pay the rent. Well, that's not true because they don't own the equity anymore. The trust does. And the trust says they can't access the principal. That's the whole point that makes it safe from nursing home care. You're not supposed to have any access to the principal. And if you don't have access to the principal when the house is sold, you can't use the proceeds from the sale to pay the rent. All you can do is invest the proceeds from the sale and hope that you get enough interest and dividends to pay the rent. And in the current yield market, that's highly unlikely. So for most families, this is a bad approach because before you need nursing home care, you're likely going to need either assisted living or in-home care, neither of which Medicaid, the welfare program that these trusts are designed to make you eligible for, neither of which will be paid for by Medicaid. So you want to make sure you have the ability to pay for assisted living or in-home care on your own. And then when you know that that's not going to work anymore, then you want to look at these kinds of approaches for trying to reduce the cost of nursing home care. Be really careful. These approaches don't work with IRAs. To use a Medicaid planning trust, you really have to cash out your IRA, pay all the taxes on it, take the proceeds, stick them in there. And again, the principal is no longer available for you. There are other techniques where you can convert a retirement account into an immediate annuity, and that might help make you eligible and not have the IRA countable. But the problem is there's a copay equivalent to this, where if you're eligible because you have no more than $2,000, the state will say, okay, we'll start picking up the cost of care. But if you have income, you have to use your income first. And that immediate annuity is going to have to be used to pay for nursing home care after the first roughly $1,700. So it's not a really good strategy if you want to be able to enjoy your own wealth during your own retirement. I think a revocable trust for most people is a better method. I think two more statistics and then I'll move on. You know, one statistic is the average cost of nursing home care is about $150,000 a year. Another statistic is the average stay is about 2 years. So that means your typical cost of care, if you do end up in a nursing home, is going to be around $300,000. Most of the clients we assist have a net worth over $1 million. Does it make sense to you to give away $1 million to save $300,000? For most people, the answer is going to be no, not really. So we want to look at it now. If it's a different situation, like you're in a car accident, you're in a coma, your body's very healthy, but you're never going to come out of your coma and you're going to be in the nursing home for many, many years. Well, then doing nursing home planning, Medicaid planning might make sense. But you want to be careful because it can also trap your spouse where when the ill patient, the patient in the nursing home finally dies, the surviving spouse still is going to be impoverished. So it takes a lot of strategy and planning. Don't do these willy-nilly. Be very careful. If you think you have one of these and you're afraid maybe you're stuck, I have to tell you, many of them that we have seen have been very poorly drafted, and we've been able to find some back doors and get people out of these trusts. So if you're stuck in one of these and you'd like to find out how maybe you could get out, feel free to take advantage of a complimentary consultation. We'll need to review your documents and see if we can come up with a strategy to get you out of one of these. All right. With that, let's move on to the next slide. Let's talk about some of these
Keats, just before you go on.
Yeah.
There's a lot of information coming at people very quickly.
Yeah, I know.
And,
I'm trying to squeeze a lot into a short period of time. I hope I'm not being a fire hydrant.
No, it's great. I just thought you mentioned that you will be having some webinars, and I just want to remind people that if they're getting some information enough that they say, hey, I really should look into this more, just be aware there's going to be more opportunities to learn more about these issues in various ways. And we'll have a slide at the back end on those dates and times, I think it was, right?
Yeah, that's right. So
you can always go to Keats's website, Boyd and Boyd PC.com, to learn more about that.
Yeah, so we're going to be doing a couple of presentations at the beginning of June to flesh some of these issues out. And then we're going to be starting our live seminars again. We'll also be simulcasting them in Zoom for people who don't want to be in a live seminar environment. We'll try to arrange social distancing still and be very cautious. But most of our clients we're learning have been vaccinated. And so I think it will be a safe situation for most people, but we'll have opportunities for that. I'll cover that near the end.
Thanks.
All right, so there's three proposals that I want to talk about. The first one is President Biden's tax proposals. Came out in his address to a joint session of Congress about a month ago. He's talked about several things that are of relevance to many families. The first one are some income tax proposals. He wants to increase the tax on incomes, families with income over $400,000. Now, there's still some debate as whether this is $400,000 for a married couple and $200,000 if you're single, or $400,000 for anybody. It sounds like it may be coming down to a $200,000 if you're single. He wants to restore the 39.6% tax rate. That's been taken out of our tax code, but this would put it back in. And so if you're in the highest tax bracket, that would shift up from a 37% rate to a 39.6% rate. And for most taxpayers, that would still mean they're going to be subject to the Affordable Care Act surtax on top of that of another 3.8%. We also would see a cap in itemized deduction. So if you itemize and you're in, say, the 35% rate, you would not be able to get benefit of itemized deductions beyond a 28% benefit. So you won't get a 35% benefit. Then we're going to restore the P's limitations. Now, this is something that, quite frankly, I'd have to defer to an accountant to explain. But again, it's something that has been taken out of the law. It's going to be put back in. Basically, it reduces the benefit of itemized deductions. As your income gets larger, you get a reduction in the benefit of itemized deductions. We're going to see capital gains increases if this law is passed. We're going to introduce a new capital gains rate. Right now, we have a 0% rate, a 15% rate, and a 20% rate. The Biden proposal would add a 39.6% rate if the gains in any tax year exceeded $1 million. Now, it's not the income, but the gains. The problem with that is we're going to see there are proposals to create new gain recognition events that aren't in the tax code. And if you accumulate all of these, it's possible, very easy for many families who would say, oh, I'm never going to have $1 million of gain. All of a sudden you could be looking at them. So this is really the danger of this particular proposal. It also will eliminate the step up in basis at death. That means right now, under the existing law, if I died, anything I own that is a capital asset, my real estate holdings, my stocks and bonds, will have a change of basis. If I buy a house for $100,000 way back when, and now it's worth $500,000, my basis is 100. If I put in a new kitchen for 50,000, well, now my basis is 150. If I sell for 500, I've got a gain for the difference between the 150 and the 500, or the 350,000. I have to pay a tax on the gain of 350. My basis is 150. If I die under the current law, we're allowed to change the basis from what I paid for the house to its date of death value. So if it's worth 500,000 on my date of death, my heir's cost basis becomes $500,000. If they turn around and sell it for $500,000, they won't have to pay a capital gains tax. This has saved untold dollars in taxes over the years, and is something that we've seen a lot of complaints from certain factors of the Democratic Party that they want to do away with this as an unfair tax avoidance strategy. People hold on to assets until they die so that the basis is changed and the capital gains tax can be avoided. So it changes the planning substantially. We'll find that we may want to be using CRTs, charitable remainder trusts, sometimes called capital gains avoidance trusts. We may want to look at recognizing gains and losses where normally we might hold them. Other techniques, what we were going to try to do is keep the gains below $1 million. So this will become a new strategy in both financial planning, tax planning, and estate planning to make sure that if we have no step up in basis and we're looking at a 39.6% tax on gain plus a 3.8% surtax on top of that, plus a 5% state income tax on top of that, we're going to be looking at ways to smooth out the gains over years so that we're not going to have that big wallop at death. The last part of the proposal is we're looking at expanding the 12.4% Social Security tax. So there'll be a break. Right now, it's around $190,000. You no longer have to pay Social Security tax. And now they'll put like, well, you get a break for a while, like they have in the donut hole for Medicare, or Medicare. Then they'll start taxing us again at 12.4%. So these are the Biden proposals. Let's move on to I think it's Sanders we have next. Yeah, for the 99.5% Act. This goes back to that whole thing about the 1%. Well, we're going to change this. Sanders proposal would have major impacts on estate, gift, and GST taxation. So first we have the estate tax rates and the gift tax rates and the GST tax rates would shift from a current bracket of 40% flat rate to Sanders' proposal would change it from 45% for many people. There'd be a 50 or a 55% bracket and then a 65% bracket for very large estates over $10 million. The estate and GST exemption, the amount you can pass at death without tax would be lowered from its current level of 11.7 million to only 3.5 million per person. Now, if you're married, you get to double that with the right type of planning, but people who use joint property would be giving up $3.5 million worth of exemption. So we got to be very careful. This could trap a lot of families that currently are not subject to tax. The gift tax exemption would be reduced. This is the amount you can gift in any year, or excuse me, I said that wrong. This is the amount you can gift during your lifetime without having to write a check out to the IRS. It is different from the annual gift exclusion, which we're going to talk about in just a second, all right? Under this proposal, the current law is 11.7 million of gift tax exemption. So you don't have to write a check out to the IRS until you give away more than 11.7 million during your lifetime. This would lower it to $1 million. So families who have already used significant amounts of their exemption during their lifetime before this law passed may not have any exemption left to use after the law is passed. So it is important that they consider gifting now, this year, before this goes into effect. If passed, this bill would be effective on January 1 of 2022. So gifting while you still have an $11.7 million exemption is critical for families over $1 million, or more importantly, over $3.5 million. Taking advantage of this now is really important. The annual gift exclusion, the amount you can give to any one person without having to file any kind of a report, is right now $15,000. It's indexed for inflation. but that would be changed under the Sanders proposal to $10,000 per recipient. Now, for Crummy Gifts, that's a really strange name. It's after a case name, the Crummy case, which a family's last name was Crummy, and they made gifts to a bunch of people and wrote a trust in a way that the gifts to each individual a gift to a trust was considered to be a gift to the individuals who were the beneficiaries of the trust. That way they could make larger gifts of $10,000 apiece to a large group of people, even though they were only giving to one trust. Well, the Sanders proposal would limit Crummy Gifts to about the equivalent of 2 per year, which is $20,000. So it would have a chilling effect on irrevocable life insurance trusts and cause taxable gifts, which would end up burning the $1 million lifetime exclusion, or for people who've lifetime exemption. And for people who've already used it, they might actually end up having to pay a tax to continue to fund a life insurance policy. So there's real serious implications from an estate planning point of view for older documents that already exist and are out there. Okay. All right. If we could go to the next slide.
Well, it's not actually the policy as much as the trust that pays that policy. Just
right.
Correct. Yeah.
Right. Yeah. Right. All right. So, well, the impact would be if we can't make the gift, how will the premium be paid? You know, if it's going to become a taxable gift, it makes it maybe no longer affordable to maintain. And we may be looking at, will policies implode? Will policies need to be renegotiated to lower death benefits? Will we not get the important death benefit that we need to pay the estate tax? Well, now estate taxes are going up. We're going to need more. All sorts of ramifications to this. So it's got a lot of impact. So the amount you may gift without having to, I was already talked a little bit about the annual gift exclusion. That again is the amount you can gift without having to report the gift on a gift tax return of Form 709. Again, it's $15,000 and it's going to be lowered to $10,000 per donee. Grantor trusts or beneficiary tax trusts will now be included in the estate as a part, if to the party who has the tax liability. So for example, if I'm a donor, I create an irrevocable trust, but I say any income earned to the trust belongs to me. Right now under the law, we can write that so I can be the owner of the income, but not the owner of the asset. Okay. It sounds contradictory, but it's the way the tax code's written. If we do that, a trust that's written that way under the Sanders proposal would cause the assets in the trust to become a part of my estate. So what we might see if this bill passes is a lot of grantors saying, no, thanks, I don't want it to be my income anymore. I'm renouncing that right. And now those trusts will be taxed at much higher income tax rates. The trust is going to pay the 39.6% tax at around $13,000, not $400,000, $500,000, or $600,000. So it's going to be much more taxable income for these trusts by having to undo that. Beneficiary tax trust, which right now is how we have our PATs designed, so that when a trust becomes irrevocable, the beneficiary will pay the tax. If that happens, then the assets in the trust will become subject to estate tax at the beneficiary's death. Now we may be playing a game to say, well, what's the right idea here? Should we defer making a decision and run the risk of dying before we renounce that beneficiary tax power? We may have the assets included in our estate, even though we might not want that. So this, again, has a lot of planning technique issues that will require annual review between the estate planning attorney and the party who is deemed to be the owner of the tax, of the income. The GST exemption, right now, that lasts for approximately 100 years. It's lives and being plus 21 years at the time the trust becomes irrevocable. So if you die with your revocable trust and your beneficiaries are your children, your grandchildren, and great-grandchildren, they're all alive when you die and your trust becomes irrevocable, that trust would be exempt from generation skipping transfer taxes until the last of those people die plus 21 years under the current law. The Sanders proposal would change that to only 50 years, in which case Then if we transfer out to a skipped generation, instead of giving it to our kids, we give it to the grandkids, we'd have a higher tax. Again, at that 45 to 65%. So it could be a very big tax consequence to this proposal. Finally, something that is used with small, closely held businesses that are done for asset protection and for estate tax reduction purposes, family limited partnerships, family limited liability companies. We would lose the discounts that we currently see on those to reduce the estate taxation of those. That's something that has been a bug for the IRS for many years. They've wanted to do away with this. This would legislatively accomplish that. All right, so that's the Sanders proposal. Next, we have a proposal by Senator Chris Van Hollen from Maryland. He's the Senate Budget Committee. He's on the Senate Budget Committee. His proposal, the big thing I want to point out is it could be retroactive, meaning if passed, it would be effective on January 1 of 2021. This one would make transfers either by death or by gift a capital gain event. In other words, would have to pay, if I died and I had my real estate at 500,000 with a basis of 150, my death would cause a capital gain event on the gain in that asset. So I would have to pay a capital gains tax on that appreciation. If I also have stocks with $500,000 of appreciation in them at my death, that would be a capital gains event. If the grand total of all of the appreciation in my estate exceeded $1 million, if it's coupled with the Biden proposal, not only would I have a capital gains event under this proposal, but I'd be bumped up into the 39.6% capital gains tax rate. I'd also have a 3.8% surtax on that capital gain. I'd also have a state income tax on that gain. And I might also have an estate tax wrapped into that as well. And so it is entirely possible that you could see heirs getting a bill and not an inheritance. Exclusions there are some exclusions that would avoid capital gains recognition. They're talking about maybe a $1 million exclusion at over lifetime or death. Well, that would work in our favor. They may keep the concept of the $500,000 capital gains exclusion on your primary residence. So right now, if you sold your primary residence, each spouse who is an owner could exclude up to 500,000. I'm sorry, I said that incorrectly. Each spouse could exclude up to $250,000 of capital gain as long as that property was their primary residence for 2 of the last 5 years. So there's talking about putting something like that into the Van Hollen proposal. There'd be some limited exception for certain tangible personal property. If you give something to charity, that's not going to trigger the capital gains recognition. And in some instances, assets held in retirement accounts would be excluded. They should be. I mean, we don't pay capital gains on them now, but there is some risk that there may be some capital gains tax exposure on assets trapped within an IRA or 401k. So there's a lot of issues with this proposal, and these are just some of them. I think if we could go to the next slide, Chris, there might be a few more we want to talk about. Income taxes paid under the Van Hollen proposal would be a deductible expense under any estate tax. So that would help avoid some double taxation. And assets held in a non-grantor trust will also be deemed to be sold every 21 years. So we're going to force capital gains recognition every 21 years under this proposal. For example, a trust created in 2005 would have a capital gain event in 2026. There's another proposal in the House that would change it to every 30 years. So what we'll actually end up with may come out of conference committee. It could be a compromise between the two, but you can see here that they're going to try to force capital gains recognitions if they pass these proposals. This proposal also allows for income tax to be paid over 15 years when the realization occurs at death. So we can spread it out a little bit, not have to pay it all at once. And that's to help prevent people from having to sell the family farm or a closely held business or something like that. But it's still going to have a major impact when coupled with estate taxes. And finally, just as I pointed out earlier, this would be effective at the beginning of this year if passed. Now, as a commentary, this is my personal opinion. I think this bill was put in place to prevent people from knowing whether or not they should act. The truth is there are back doors that we can build using this legislation to say, here's a way of transferring assets now, not going to trigger the capital gains event, but we can wait and see, and then we can make it go where we really want it to go by using a disclaimer or a renunciation or something of that sort. So there are possibilities here for planning. This is really meant to stop people from planning so that they're going to get trapped and not be able to get around the law, because if they wait until we finally know what's going to be the case, it may be too late. We may be into next year and you can't do the planning because the new laws will be effective next year, for example. So I don't want people to be terrified about planning. These proposals, this one in particular, in my opinion, is meant to stop people from planning. And I think it's really important that people take this year and take steps. And as I said, we can build, quote, backdoors to try to protect against unwanted tax recognition, like a capital gains event occurring, by giving, for example, to a spouse, or building maybe some charitable bequests in here in some fashion, but using trust to transfer assets maybe down to the next generation to get them out of the estate. So we're not going to have an estate tax and a capital gains tax. That may be a good move right now. All right, Chris, thank you. So from an income tax planning perspective, what can you do now? Look at harvesting your capital gains before this law passes, before we're looking at a 39.6% rate. Even if you're in a 37% rate, by recognizing gains now, you may be saving tax dollars. Start planning for no step up in basis. Make sure you've got records. You know, if you bought your house 40 years ago, try to put something together and keep it in a place where the kids will be able to find it, because they won't know. And if they don't have any record of what your basis is, their basis is going to be zero, and they're going to have to pay a capital gains tax on every dollar. So start planning for no step up in basis. It looks like this is going to happen, and it's probably going to happen, in my opinion, through reconciliation that will have the step up in basis done away with. I can tell you historically, this has happened twice in my lifetime where basis step up was eliminated. But I can also tell you it's been put back in place because it was such a disaster. So I don't expect it to be a long-term thing, but you want to have records in place and plan for it, because God forbid you pass while it's the law, your family is going to be stuck with no step up in basis. A standard practice everybody should be looking at is loss harvesting. If you have a capital loss at any given point in time, you may want to recognize it so you can use it to offset gains in the future. Whether it's gains in the current year or gains in future years, a capital loss that you've recognized can be very helpful in tax reduction, especially if you don't have capital losses. If you've got ordinary income, your capital loss can be offset against that at $3,000 a year. If you're in a bracket that's higher than the capital gains tax bracket, you know, for example, if your capital gains tax is a 15% bracket, but your ordinary income is at 35% under a new law, well, being able to use that loss to offset 35% income, you're going to get more bang from your buck. So make sure you're doing loss harvesting every year at any opportunity where you have losses. If there's a dip in the market and you see some of your stocks or bonds go down, it might be a good time to sell those, that holding, put in a place marker holding that's of something equivalent so you don't get caught by the wash sale rules, and then buy it back 30 days later. I think we're going to see an increase in use of charitable remainder trusts and charitable lead trusts. I don't have enough time to really get into these techniques today, but these are something that I think we'll likely see. Installment sales, where you're spreading the gain out over a period of years, is an important technique. Opportunity zones, certain areas that have been targeted as great for development because they need some economic improvements. If you're willing to run that risk, that might be a worthy real estate investment. And then finally, 1031 exchanges. If you have investment real estate, take advantage of the 1031 exchange, although there's some fear that those could be eliminated in the future. But if you can do it this year, it might be the right time to do it. All right, Chris, thank you. Estate planning, the Van Hollen bill, I think, is an attempt to chill planning for the rest of the year due to its retroactivity. But I don't think clients should not plan. I think you should be planning this year in anticipation of these law changes. There is some risk. We'll go over the pros and the cons and help you decide what's right for you and your family. But you need to be taking proactive steps right now before the law changes. And I do think it's likely to change, at least effective next year. Gifts. One strategy would be to make cash gifts, even if you have to borrow to make the cash gift. So, leverage an account. If you need to use a margin account, perhaps careful with that. There's risk, but gifting cash, you're not going to have a gain recognition event. So if you have, a cash portfolio, CDs, money market accounts, things that are cash equivalents, those could be very good to make gifting with this year, because even if the Van Hollen bill passes, it's not going to trigger a capital gain event. Make sure we have disclaimers built into any planning. So if you give something away and it turns out that, 2 senators die and they're replaced with Republicans and none of this is ever going to get through with reconciliation, well, then we have a method to undo the planning through a disclaimer. The kids can say, no, thanks, I don't want it. Let it go back to mom and dad, and we can get you your assets back. So disclaimer planning is going to be an important consideration in everything that we're putting together for irrevocable trust planning to reduce estate size. So, again, my point here is there are back doors. There are a lot of opportunities to do planning now, but build in something in case this doesn't come to be. One of the techniques that I really like is a takeoff on a spousal access trust. Now, I've been talking about spousal access trust for several years as a great asset protection, estate reduction, and income tax planning tool. You can create an irrevocable trust for your spouse, put assets into it. They're not owned by your spouse, and they can be structured from an income tax point of view a number of different ways. But the income can be distributed out to the spouse, and maybe even some of the principal for reasons of health, education, maintenance, and support. This is the standard that has been used for trust for decades. As long as I've been practicing, we have used that standard as a way of avoiding estate tax. Now we're saying, let's do this instead of waiting until we die. Let's do it now while we're alive, and then we can do it again when we die. So we create this kind of a trust for our spouse, get assets out of the estate now, and maybe even still get it so it can go back to the spouse who created the trust in the first place. So if the spouse who receives the gift is the first spouse to die, we can make it so that the surviving spouse, the spouse who created the trust, can still get benefits, but not own it and avoid estate tax. This is really a brilliant proposal. I don't know who came up with it, but it's trickled down through some of the CE that I've seen on these statute proposals. And I think it's a really good idea. So, that's something that I'm putting out to a lot of our clients and recommending as a positive step. So this is a little continuation on that. I think for time purposes, Chris, I might skip through and not get into the details of this, but if anybody's interested, I'm happy to talk about it. That last particular portion and some of the summary of these 3 bills has come from presentations from Jonathan Blottmacher, Professor Mitchell Gans, Robert Keebler, and Martin Schenkman, who all deserve credit for a lot of the information that I've gathered, as well as from learning about the laws by reading the proposals. So anyway, the next thing we should talk about are limited liability companies. This is really one of the great tools to say, what's in estate planning for me? If you're doing planning, years ago, I had a client come to me and I said, oh, you should do this, you should do that, you should do something else. And he looked at me and said, yeah, all of these benefit my kids. What's in it for me? And an LLC is really the perfect solution to that. It can provide you with great asset protection. It can provide you with income tax changes so that if you're in one bracket, we can shift it around. Perhaps if you're in a high bracket, we can maybe choose C corporation status and move it down to what's currently the 21%. President Biden's proposing to move it up to 28%, but that still might be less than a 32 or a 35% bracket. So we can shift income or lower the brackets and save money on income taxes through some of these proposals. A limited liability company is really a closely held business. It has to have a legitimate business purpose, managing real estate, managing portfolio design, maybe diversification, helping the kids learn how to work with an investment advisor and manage the family money. It provides a lot of great benefits, and it provides asset protection so that if there is a divorce, a bankruptcy, a lawsuit, the problems of a member, a stockholder effectively, those problems can't break through the LLC to get at what it owns. And so it's really important that you consider one of these. Don't try to do it yourself. I know you can go online to LegalZoom and set up an LLC on the cheap, but they're going to set one up in Massachusetts. Massachusetts has, or whatever state you happen to live in, they're not going to look at what jurisdiction is the right one for you. And so it's really important. We look at states across the country. We are organizing LLCs in multiple different states for different objectives. And we're looking to the state law that's going to provide that family with the best protection, best income tax results, and a number of other benefits. We want to protect from outside creditors, the people trying to break through the LLC to get at the assets, as well as inside creditors. The tenant who slips and falls, we don't want them to break through the LLC to get at your home or your bank account or your savings or other investments. So we want to protect against that. And we put onto this somewhere, Kathy has posted for us a handout that will give you more information about the non-tax benefits of a limited liability company. So consider that as part of something you should add to your estate plan. All right. Chris, if
Kathy,
you
do you want to share where that information can be found, if you don't mind coming off mute?
Yes, it is on our website on amrfinancial.com, and I am going to text it to everybody right through Zoom, so you'll have it momentarily.
Thank you,
Okay,
Kathy.
thank you.
That's great. Appreciate it. All right. Next, I want to turn to blockchain. This has become an increasing area of interest. In estate planning, we've been talking about digital assets for a little while, making sure that we have ways of passing assets. And, you know, over the last couple of weeks, as I've learned a little bit more about blockchain, I realized that estate planners are looking at this from a very backward standpoint. And I'm going to give you a little bit of a presentation from that standpoint, but then I'm going to shift the paradigm a little bit. So Chris, if you'd go ahead. So first of all, I'm not talking about Bitcoin. I'm not advocating investing in Bitcoin, Ethereum, or any of these other cryptocurrencies. They are speculative. And quite honestly, you know, if you wouldn't be interested in investing in the Australian dollar, the euro, the Great British pound, the yen, or any of these other currencies, if you're not going to invest in any currency, you shouldn't be thinking necessarily about investing in cryptocurrencies. It's not the investment strategy here that's interesting. It's really the technology. This is built on a technology that uses peer-to-peer networking, which adds a level of security that you don't get. Most business structures use a server-based network, meaning you've got one computer that holds all the data, and everybody at their own desk pulls into that computer to get data, work on it, and put it back. Peer-to-peer networking is there's 10 different computers all around the network, and each one holds data on their own computer, and they all share with one another. Now imagine having a ledger. You know, if you, let's say you were a banker, for example, and you had to keep record of who had accounts at your bank. You know, if you have it in a server and you've got the Russian hacker who wants to find out, you know, all the information about bank accounts, and they hack into that server, they can get all that data. But if that data is spread out amongst a variety of computers, that's much more difficult for them to get at. Add to this technology, it uses one of the most sophisticated encryption technologies that's out there. It's a standard that's used by the NSA for sending secure messages for a variety of governmental purposes. And this technology is added to it. So you've got this encryption of the data that, you know, and what happens is this ledger of who owns what is being changed every minute, because Bitcoin or Ethereum, they're all changing hands rather rapidly. And the records of who owns it are being updated constantly around all of these computers. Now, if one of the computers got hacked, they'd have to back into and undo the encryption. And in order to do that, it would take, on the slide here, it says 1.157 times 10 to the 77th power in calculations. That's going to take time. It's not something that can easily be done, even by a super fast computer. And even if you could get in and change the record on one, the rest of the computers are going to say, no, that one doesn't agree with all of our records, so we're going to reject it and exclude it from the record of the ledger. So now all of a sudden, you've got a very secure system for keeping records of who owns what. Now, I don't know about you, but I listen to Sirius XM radio in the car often, and I've heard a lot about title lock. You know, it's one of those things where you can make sure nobody can take the title to your home. So they monitor what happens at the registry of deeds so that there's nobody who says, well, I'm really the owner of 123 Main Street and I want to go put a mortgage on it, and you don't even know about it. You never sign anything. It's all fraudulent. And then you get notices of foreclosure trying to foreclose on the home for a loan you never obtained. The possibilities of this technology would be to tie that encryption and that peer-to-peer networking into real estate title, into ownership of gold bullion, ownership of arts and other things like that. So it really has enormous potential to create a record of who owns what. One of the ways this is done is through something called a non-fungible token. You know, most of the tokens we've heard about are the Bitcoins or the Ethereums. These are coins that are tokens that are used to represent ownership of something, digital asset on these networks. Non-fungible tokens are being used with other tangible personal properties, very often collectibles, such as art, stamps, tickets, a number of different things that are out there. You know, imagine that you could get a thumb drive with a piece of artwork on it that you could then plug into your TV and watch a video, music, or listen to music, or look at artwork, maybe have it projected onto a canvas. All of this is going to be the artwork. It's one more medium for artists to express themselves. And what it does is it secures ownership so that if I post a picture on the web, how do I know somebody's not going to copy that and sell it in violation of my copyrights? You know, without getting political, we know there's some of that type of thing going on with China transfer of technology. So maybe this is a way of trying to protect against that technology transfer. So there's a lot of possibilities with this. It's something where we're going to see the middleman is going to start to be eliminated. The art gallery, the publishers, the record labels, because artists will be able to do this on their own on the blockchain and then go to places where NFTs are sold. They're already doing this. I saw something by Snoop Dogg as art the other day that you can purchase an NFT for about $500. That's a unique one of 44 different things that are going to be sold by Snoop Dogg, if that's your thing. So, you know, it's another medium where this is going to become very popular, I think, in the next little while. All right, Chris. Finally, we've got DeFi, which is decentralized finance. You know, remember the peer-to-peer network, we're decentralizing everything. We're not doing one big server, we're doing a bunch of different computers on a network. Well, that's going to impact financing. Things like banks, credit card processing, lending, all of these are going to be changed dramatically through this market and will allow for cross-border transactions that will be seamless without fees by these middlemen anymore. So it allows the consumer to decide how their data is going to be used. You know, if I've got my data on the blockchain and I own it, not Facebook or Google, well, now I can say to Facebook or Google, if I'm so inclined, I'll let you lease my data so you can sell it to your advertisers, but you're going to pay me. One example of this already is a browser. You know, many of us use, you know, the Microsoft browser or Chrome. Well, there's another one called Brave. And this one, instead of forcing you to watch advertising that their advertisers pay, you know, when you do a search, you see all the ads pop up near the beginning of the search results. Brave doesn't do that. Brave will say, hey, I'll pay you to watch advertising and you can choose to opt into it. If you don't switch the advertising on, then they won't show you ads in search engine. They use DuckDuckGo, which is a search engine that, again, doesn't use advertising. So you can then be paid for your attention. They do it in a cryptocurrency called BAT, basic attention tokens. And right now, these tokens are trading at a little over well, I haven't checked today, but last I saw they were trading a little over $1 per token. So you get paid for watching advertising. So again, it's changing the paradigm here. So that the consumer is now in control rather than being controlled by these Goliath companies that have access to all of our data. So it's a really incredible change of technology. Chris, if you could change, there's one more point that I want to get to. Traditional estate planning for blockchain assets would say, well, you got to own your blockchain assets in a way that will fit with your estate plan. Create an entity, have them all owned by the entity. And so when you die, the ownership of the entity transfers. That still means the blockchain asset will transfer to the new owner without having the change of ownership at the blockchain level. Trusts, put your blockchain assets into a trust, and at your death, a new trustee just takes over because the trust didn't die. But really, blockchain is about using smart contracts, a contract that can execute itself because the terms are built into the agreement. It's a series of coding, programming that basically says, if I die, condition one, then give my assets to whoever it should be. So you can build code to do this kind of self-executing contract, so that really what we should be doing is, instead of planning old school with blockchain assets, we should be using blockchain to transmit our assets at death. I can see that within 10 years that the traditional paper trust that we write will be replaced with a digital smart contract trust that's built on the blockchain. And so this is something that I think is the direction we will be going in. It will greatly enhance the privacy of your estate plan. Even though a trust is very private now, you are still often required to provide copies of that trust in full to a mortgage company if you're trying to refinance your home, or at least certificates of trust to the registry of deeds or other places where there could be part of the quote public record, or banks or financial institutions. With the blockchain, that won't be necessary at all, because you'll just have a digital ID, and that will really be all that's required. And it will, I think, in many ways, eliminate government oversight and regulation that will make transfer of wealth much more efficient. It won't necessarily eliminate taxation. As a US citizen, we are subject to our taxation rules, and the government does currently consider the exchange of cryptocurrency to be a capital gain event. So we'll still have income tax, and we'll still have estate tax on the value of cryptocurrencies that are a part of our estate. So I don't think it'll help on the taxation side, but I do see within 10 or 15 years that we're going to start seeing these smart contracts be a part of the estate plan and replacing certain components of the estate plan that we're currently using. All right. I've probably gone a little longer than we thought. I think I'm all set, Chris, on that slide. There we go. So we just have a couple of upcoming seminars. On June 1st, tentatively, we're going to have one at 10 in the morning. That will be a more in-depth version of the 3 tax proposals that I've talked about. I'll get into, some of the techniques that we can use to avoid some of these taxes. And then I'm likely to I want to do another one on blockchain, get into greater detail, explain a little more of the concepts behind this, because I know that a lot of this stuff is beyond the understanding of many people. And I want to get into some of the groundwork and be able to explain it so that perhaps we can see how this will benefit us in the long run. So with that, I think I'll turn it over to Chris for Q&A.
Okay, Keats, thank you. A lot of interesting content and thought-provoking considerations. I think it's the notion of blockchain remains one of these things. How it will be implemented and utilized is to be determined. I think, you point out that there's some really interesting possibilities as to how it could be utilized. I recently heard a discussion how blockchain, a current investment of interest trend lately, and yet it's in contrast to another investment trend which relates to ESG investing because of the energy consumption that is required for that computing that you were talking about,
Right.
the massive amounts. So
Yeah.
we'll be
So
interested
that
to see
relates
how some of these
particularly
things
to
evolve.
Bitcoin.
Pardon me?
Bitcoin, through the way they develop and prove ownership, it takes about 10 minutes of computing power, and it's being done by a bunch of computers at the same time, and that uses a fair amount of energy.
Well, I think that ultimately comes back to that notion of blockchain, that blockchain technology that has this back and forth of where the information is retained and confirmed
Yeah.
in encryption process.
But the thing is, much of these contracts, the smart contracts, are not going to be written on Bitcoin. They're going to be written on Ethereum, which uses a different method of proving that the update to the ledger is accurate. And so, while what's Elon Musk, he made his comments last week, and that really triggered a sell-off in cryptocurrencies. I think for these Ethereum-based languages and tokens, it's a different thing, and there's not the same energy consumption because the proof of the blockchain is done through a different algorithm. It's done through proof of stake rather than a different proof, which I can't recall off the top of my head.
Well, it's interesting. It's interesting content, and
Yeah.
something we'll certainly all be paying attention to more closely.
Yeah.
We do have some questions, I know, but for those who have been listening and have questions about any of the topics we've discussed today, we're available to take those questions now. Again, to remind you, you can raise your hand if you'd like to ask a question verbally. We can, when we can release, the unmute your line to address your question. You can type something into the chat area or post something in the Q&A section. So all of these are possibilities. Kathy, I think we had at least one or two questions perhaps already. Would you share with us the nature of some of these so far?
You bet. We've got someone who has been very patiently waiting to get their question addressed, and I'm going to read it exactly as it was written. With a new granddaughter, are we better served to set her 529 education account as part of our trust? And they're going to be setting up a trust this summer.
Okay, so generally speaking, no. That's one asset I would not put into a revocable trust or an irrevocable trust. It's already a custodial account in essence. It's somewhat of a trust itself. You're putting money into it, you're holding it for the benefit of that granddaughter so that she can use it when it's time for her to go to school. What I would urge is that you check to make sure you have a backup custodian to yourself on the records where the 529 plan is invested. So for example, if you set up that 529 and you're the custodian, so you get to manage and pick and choose the investments, if something happened to you, who would be in charge? You can name that person in advance, and you should. If you don't, then there's a requirement by many companies to have a probate procedure called a conservatorship established. And that's a timely and consuming process, and would stay in probate court until the child reaches the age of majority. So you want to avoid that at all costs. On another side, I would also consider not making the parent of that grandchild the backup custodian, because once they are on the account, they would have a requirement to disclose the existence of that 529 plan on what's called the FAFSA, the federal, I forgot, the application for financial student aid or something like that. I forgot what the acronym stands for, but it's the federal form that you have to fill out to apply for financial aid at every college in the country. And if the parents are aware of it, they're going to have to disclose it. If you are the custodian, technically they don't, many times you have the right to change who the beneficiary is. And if that's the case, they don't know that their child is going to get the benefit of the 529 plan. And so they would not disclose it, and it would not impact that grandchild's eligibility for other needs-based financial aid. Now, if the parents are well off, they may not get any needs-based aid anyway, so it won't matter. But if it's a close call, that can help.
That said, if that's the case, if the grandparent is the owner, it would be wise not to have the child use those funds until their junior year. because the child will be perceived as having the income as far as some of that financial aid is concerned, and it could disrupt their financial aid as well, something along those lines. So it's a little more complex, but we also would say it's probably not in your best interest to use a trust as the tool, and it would be a matter of choosing given the expectations of financial abilities of the parents versus the grandparents in that scenario.
Another tool that I just want to mention, it's not really appropriate for a young grandchild, but if you have grandchildren who are attending any kind of educational institution for which there is tuition due, it could be a private school, high school, or undergrad or graduate school. It is possible to make a gift of tuition directly to the institution. And it will not count against any of the annual exclusion or lifetime gift exemption of the person who makes that payment of tuition as a gift for the benefit of the student. So that's something that you might also want to consider. There is actually a case where somebody knew that the student was going to go through 12 years of education at a private school, gave all 12 years of tuition, prepaid it all for the child, and that was upheld to be a valid, non-taxable gift, not reportable by anybody. And so it's just one of the things that you may want to consider. You do run some risk if you prepay future years that if the child decides to transfer, the tuition does not transfer with them. So, the school would get to keep the tuition. So, if my child went to, I don't know, pick a school and at the end of their freshman year said, I hate it here, I want to go somewhere else. And my parents had prepaid 4 years of tuition to the school they first enrolled in, the last 3 years would be lost. Okay.
It would be transferring in that case, right? No.
We'd probably want to discourage it, but you never know.
One other quick correction, that was a minor comment, a throwaway comment, Keats, you made, was just where that FICA tax threshold was. It's $142,800 of income for 2021. Right. I had the benefit of looking it up while you were talking.
Thank you. All right, I appreciate it. I was just roughing it in, so I appreciate
it as
the
a throwaway comment. I just wanted to share that. Kathy, do we have any additional questions at this time?
We don't right now, Chris, but available to take a few more.
I think, we'll give it a minute while we just have some concluding comments. I think there's a couple of things to take away from our discussion today, Keats. One is the idea that if you haven't updated your estate plan as a consequence of legislation over the last couple of years, there's some things to be looked at and to be addressed, and it's important to do that, number one. Number two, many people who've thought about an estate plan have done so with the intention of trying to avoid Medicaid spend down, protect their assets for the next generation. But you made some compelling points that this may not be a prudent approach unless you have some reason to believe you have an impending long-term care expense, at least depending on the size of your estate as you think about it, because it really can limit your access to your wealth. And that's not always a good thing.
Right. If I may, for just a second on that, just to carry on that last comment, this is rough rules of thumb, never wholly accurate, but just to give people a gauge. If your net worth is less than $750,000, a Medicaid plan as your standard estate plan might have merit. 750 to 3 million, you're in a gray zone. It's not clear. 3 million and up, it's black and white. You probably should not be doing it until you have that diagnosis. And even then you probably shouldn't do it. But what's right for each family will vary.
And then, I think just to conclude on the earlier comments about the estate planning discussion, I think it's one of these things where you may want to attend an upcoming talk because there's more time to get into areas of detail depending on your area of interest, and to check out some of those additional webinar or seminar events. They can go to your website, boydandboydpc.com. maybe we can come back and check in on some more of the tax comments in just a moment, but it looks like, Kathy, we have another question available to address.
Yes. I will read this. It is, under any of the three pending proposals, will a distribution from a Roth IRA be subject to income tax and or capital gains tax?
None of the proposals will take a Roth IRA that has already had all the tax paid on it and convert it to taxable income. Could that change? Yes. Do I expect it to change in this round of legislation? No. I think that might come at some point in the future if we're really trying to raise new revenues. They might look at saying, well, what we'll tax is the appreciation on the Roth. That would be the only thing I think they could possibly levy a tax on. Now, again, that has not been proposed yet. And there's nothing to my knowledge.
Perpetually a fear that people have is that the Roth IRA will somehow become taxed.
Yeah,
And
I think,
it is a
I
possibility,
understandably
but it is
so.
highly unlikely and improbable, I think, at this point. I think it's more likely that it would be disallowed going forward, that, there would be the discontinuation of new additions to a tax-free environment more so than but again, this is speculation. But
Speculation, yeah. Yeah, I do think that one of the tools that many families should be looking at is converting a traditional IRA to a Roth, especially this year. We have a very favorable tax environment right now, and the proposals to change the income tax bracket would be effective next year, with the exception of the capital gains recognition events that the Van Hollen proposal puts forward. So, to do a Roth conversion this year, I think makes a lot of sense. You've got, if you're in a 22% bracket, if you're at the high end of that, I'm sorry, the 24% bracket, you're at the high end of that. Next year, you could be in the 35% bracket if your income is the same. So you'll be paying more tax dollars on the same level of income under some of these proposals. So, doing a Roth conversion this year, and maybe even bumping up a couple of brackets, might make a lot of sense, because you'll still be paying less in tax dollars by doing that than you would by waiting until next year and trying it then.
And it's important to remember that the tax rates are subject to change in a couple of years anyway. So,
Yeah.
You're going to have higher taxes in the future, irrespective of, what happens. It's a greater likelihood that's going to happen sooner and maybe at a higher level than what the expiration of the Tax Cut and Jobs Act rates would imply.
Yeah, so just to tag on that, what Chris is
Roth
referring to is the fact that the current law expires in 2026. And we're going to go back to what the law was before if nothing happens. But now we're looking at proposals to accelerate that and actually put in higher tax brackets than what was under the prior law. So, it's a very interesting time, very interesting proposals, but I think we need to be proactive in our planning and start taking steps as soon as possible. Don't wait, because if we're waiting until December, we're not going to be able to help everybody. As it is, it's difficult to keep up with some of the workload that we're seeing. And we want to make sure that people have the time to think about it, understand what they're doing, and getting the right tool in place as soon as possible.
With that in mind, both of us have the ability to help clients to do some assessment of the virtues or drawbacks of whether or not to do a Roth conversion. So if you need help in that process, if you're dealing with your estate planning, talk to Keats about that. If you're dealing with us with your portfolio, talk to us about that, or your financial planning. With that, the tax issues, there's a lot to summarize there, but I think the point is, the handwriting's on the wall. We know that tax rates are going to be going up. We just don't necessarily know how quickly, whether it's going to affect this year or more likely next year. And therefore, there may be opportunities to give some thought to some tax planning strategies, whether it relates to your capital gains, the Roth conversion, or other techniques that might be more elaborate as it relates to your estate planning dynamics. And so take some time to give thought and discussion to those possibilities and opportunities. Fair enough, Keats?
Fair enough. Yeah.
Okay, with that, I think we've gone about an hour and a half, and maybe it makes sense for us to wind things down. I'm not sure if there's anything else you had in mind, Keats, to parting comments.
No, I don't think so. I'd just like to thank everybody for your attention and hope it was informational and beneficial.
We will be posting this presentation to our website, amrfinancial.com, on the client section. So if you didn't get to attend the earlier part of this and you want to catch the other remarks, feel free to check for it. Or if you have family or friends you want to share this with, please do so that way. Okay, with that, thank you, everybody. Reach out to us at any time if we can be of help with any of your planning issues, financial planning or portfolio management. We're here to help, and we hope we can continue to do our best to serve you. And we appreciate the trust you place in us. So thank you.